Welcome to this presentation in which we're going to be covering the chapter about, let me go over here, the chapter about liability division. So let me go ahead and go into that chapter. It's chapter 15 in our textbook. Let me go down here for that chapter. The chapter is entitled Joint Liability, but when I hear the word joint, at least I think of two parties being involved, but you can actually have many more than two defendants who are sharing or who are participating in some way in the liability of each other. So let's get started. We're going to talk in this lecture about all five of these categories: joint and several liability, the first topic; satisfaction; contribution; release; and indemnification. And we'll see at the end, indemnification kind of loops back around to contribution in certain ways. So let's talk about this first item briefly, and then we'll talk more extensively about it when we get to that particular slide. With joint and several liability, each tortfeasor is liable for the entire loss if the loss is indivisible. Let's pause for a second, a little reminder about what tortfeasor means. Tortfeasor is someone who has been found liable for a particular tort. So this is a defendant in a case in which the plaintiff has been successful. And we find out that each tortfeasor under a joint and several liability theory is liable for the entire loss, not just his or her pro rata portion of the loss, but the entire loss in cases in which the loss is indivisible, which is usually what's happening. So let's go over some vocabulary. First of all, we have the idea of joint tortfeasors. In most cases, we'll see that the tortfeasors are joint. These are two or more persons, and of course when we use the word person in the law, we're not talking exclusively about human beings, but these could be corporations, governmental entities, partnerships, associations, or they could be flesh and blood human beings too, or some combination of those things. So we have two or more entities who act in concert to produce a negligent or intentional tort. And when we say in concert here, we don't necessarily mean that they have some detailed plan where they're kind of co-conspirators. What it means is that their actions together produce the tort. It may not have been by any kind of grand design. They may not even been aware of each other. The example that I have here is two drag racers, but only one caused an injury, but they were both drag racing, and so they were acting together in that situation. It could be a car accident where one driver swerves into a lane, the other driver slams on his brakes, a third one is not paying attention, is driving too fast and hits the cars, or something along those lines. These people didn't know each other beforehand. They had no plan to be in an accident together, but each one of their actions contributed to that overall event where the car accident happened. Another term to consider in addition to joint tortfeasor is concurrent tortfeasors. Actually, I apologize before. When I was saying a joint tortfeasors, I really meant concurrent tortfeasor. So let me back up and make it a little bit clearer. I apologize. A joint tortfeasor is when they are doing the same activity. The activity at least is planned together, although they certainly don't intend the tort. Concurrent tortfeasors is like what I just described, where each person is acting independently, but their actions together in combination cause that tort to happen and cause the injury. So the concurrent tortfeasors is the one car racing, the other car swerving, the third car slamming on brakes unexpectedly, or something along those lines. So in either case, though, I've made a big fuss about defining these two terms, but in both cases, whether it's a joint tortfeasor situation or a concurrent tortfeasor situation, there's no difference in the legal outcome. In both cases, the tortfeasors are going to be jointly and severally liable. I have a little typo there. I apologize. That period ought to be after the E. And this happens when the apportionment is indivisible. Now, if you can segregate the loss and say, well, that portion is attributed to that tortfeasor's action and that portion is attributable to that tortfeasor's action, you could separate them. But most of the time, that's not the case. Most of the time, each party kind of contributed to the overall accident, and you can't separate them. So the usual answer is going to be that it's indivisible, and therefore the parties are the defendants are jointly and severally liable. That is by far the most common result. Let's talk about the rules in Texas. In Chapter 16, we'll talk about tort reform, but we've already kind of touched on these topics before. I said that all the defendants are jointly and severally liable, but that's not true. In Texas, after tort reform, the only defendant who is going to be jointly and severally liable is a defendant who has over 50% responsibility for the accident. So let's think about a couple of scenarios. Imagine we have Bob. In our first scenario, he's 40% responsible. And then we have the plaintiff. We'll call her Louise. She's 10% responsible. And then we have Anne. And Anne is, we'll make her 30% responsible. And then we'll make David 20% responsible. Hopefully that adds up. Yeah, it looks like it adds up to 100. So all of the tortfeasors are under 50% responsible. So if it ends up that Anne is insolvent, in other words, she's judgment proof, she doesn't have any money, she's not going to be able to pay it, Bob only has to pay his 40%, what the jury found he was responsible for. And David only has to pay only his 20%. Neither Bob nor David are responsible for Anne's 30%. The plaintiff becomes responsible for that amount. Louise does. But let's switch up the percentages. Instead of Bob being 40% responsible, now Bob is 51% responsible. Louise is still 10% responsible. Anne is now 20% responsible, and David is 19% responsible. Okay, so Anne is still judgment proof. She has no money. So the plaintiff can collect all except for her own responsibility, her 10% responsibility. So she goes to David and says, hey, David, pay me my 19%. David pays up. Then she goes to Anne and says, Anne, pay me my 20%. Anne says, I don't have the money. And Anne isn't lying. She doesn't have the money. So then Louise goes to Bob and says, hey, Bob, pay your 51%. Oh, and by the way, also pay Anne's 20%. So pay a total of 71%. Because Bob's liability determined by the jury is over 50%, then he is jointly and severally liable for Anne's amount. He'd also would have been jointly and severally liable for David's amount if David had been judgment proof. So that's how that jointly and severally liable works in Texas. Let's talk about a settling situation. Let's imagine that David had settled his claim against Louise, maybe before trial, maybe after trial. Then when the jury was considering liability, David would not be a defendant in front of the jury, but the jury would still be instructed to assign a percentage of responsibility to David. It might match whatever David and Louise had negotiated. It might not. It might be greater. It might be less. So the actual agreement between Louise and David would not control in terms of assigning the percentage. It would be what the jury finds. Now, in that situation, let's say that the jury found that David was 60% responsible. Anne is 10% responsible. Bob is 20% responsible, and Louise herself, the plaintiff, is 10% responsible. So Louise settles with David before trial, and Louise gets some settlement out of it. Then the jury again returns these percentages, and it ends up that Anne is still judgment proof. Louise is able to collect the 20% from Bob, but when she goes to Anne and requests her 10%, Anne says, "I don't have any money," and she's not able to, and Louise is not able to get it from Anne. Well, Louise might be tempted to go to David and say, "Hey, David, the jury found that you were more than 50% responsible, so you need to pay Anne's portion." But guess what? David isn't required to do so because he has a settlement agreement, and that excludes him from that task. Now, then Louise might go to Bob and say, "Well, Bob, we'll say Bob's percentage was 21%, and Anne's percentage was 9%. Louise might say, "Well, Bob, of the non-settlers, you're over 50% responsible. I'm just 10%, Anne's just 9%, you're 21%, which is more than half. So you need to pay Anne's portion, her 9%, since she's judgment proof." But that's not how it works, because Bob will say, "Well, yeah, I'm 21% overall, and that's what's important. It's not my amount compared to the non-settlers. You chose to settle with David. Your actions in the settlement can't suddenly cause me to have more legal responsibility than otherwise would have had." And so that's not going to work. So the settler can't be forced to pay for judgment-proof defendants, and the non-settlers get a break on their percentage of responsibility with the inclusion of the settlers in the calculation that the jury is going to make. Here's the actual statute. I'm going to have several slides here that cover the actual statute in Texas. Amount of liability except as provided in subsection B, which we'll see in a second. A liable defendant, let me stop here. When we say liable defendant, this is one that the jury has found liable. That's what that means. Is liable to a claimant. Who's the claimant? Well, that would be the plaintiff. Only for the percentage of the damages found by the trier of fact. Who is this usually going to be? The jury. Could be the judge in a bench trial, though. So a liable defendant is liable to a claimant only for the percentage of damages found by the trier of fact equal to the defendant's percentage of responsibility with respect to the personal injury, property damage, death, or other harm for which the damages are allowed. So this is saying, generally speaking, the rule isn't going to be joint and several liability anymore in Texas. But there's a huge but here. Let's go to the next slide. Notwithstanding what we just read, each liable defendant is, in addition to his liability under subsection A, jointly and several liable for the damages recoverable by the claimant under this statute with respect to a cause of action if, and here we have that greater than 50% clause, the percentage of responsibility attributed to the defendant with respect to a cause of action is greater than 50%. That's one way that joint and several liability works. The second, and you can see there's an or here, it's not an and, so the plaintiff is just going to have to establish one of these. Either this is the case, and therefore that party is jointly several liable, or this is the case. I mean, it might be the case that both are the case, but the plaintiff only needs one. So let's see what the second category is. The defendant with a specific intent to harm others acted in concert with another person to engage in the conduct described in the following provisions of the Penal Code, and in so doing proximately caused the damages legally recoverable by the claimant. And you can see, basically, they're very bad, serious crimes. So that's the other way of having responsibility. So even if the defendant is less than 50% or less responsible, if he committed one of these crimes and had the intent to harm the plaintiff or plaintiffs, then that person will be jointly and severally liable. Okay, and let's look at another statute that, as you can see, is shortly after this in the code. And this is the one that says that we're going to include settling parties, and not just settling parties, but each responsible third party. So it's not just going to be the claimant and the remaining defendants who the jury is going to decide to apportion a percentage of responsibility. Not at all. It's also going to include those settling parties, which makes sense because needs to add up to 100%, but if you don't have 100% of the people that are responsible, then that number is not going to have a lot of meaning. Then we've already covered this one, or we've already covered this concept, but let me just briefly touch on this. A person against whom a judgment is rendered has, on payment of the judgment, a right of action to recover payment from each co-defendant against whom judgment is also rendered. Okay, so this would apply in a situation, remember when in our scenario where we had Bob being 51% liable, and he pays not only his percentage but also Ann's because she's judgment proof? Well, he is going to be required to do that with respect to Louise. He'll have to pay Louise that amount of money. But Bob can then turn around and sue Ann and say, hey, Ann, you owe me that 9% that you were supposed to pay. And obviously Ann at least at that same time doesn't have the money. She's judgment proof. But maybe she's going to win the lottery. Maybe she's going to come into a fortune. Maybe they're going to find oil on her land. All kinds of things can happen that change her financial situation. And once Bob becomes aware of that, then he's going to be able to proceed. And in fact, he can proceed he doesn't have to wait. He can proceed immediately and then have a judgment that he can execute at some later time. So it doesn't mean that just because Bob has to pay it to Louise, it doesn't mean that Bob can never get satisfaction from Ann. Now, I'll be honest with you. The odds of Ann coming into a fortune is probably not that great, but there is a mechanism that can sometimes kick in. Let's see. Let's go on to Hall versus Dupont. This really isn't the way the law works in Texas. I included this little case brief so that you would have access to the information. One thing to notice about this case brief, it's more important to know about it from the perspective of, you can see, you don't need to know the name of this case, but this is how a case brief works. You have the issue, you have the facts, and then you have the analysis, the holding of the case. And this shows how, in this particular case, the defendants were working in some kind of collusion and therefore they were jointly and severally liable. But again, this isn't the way the law works in Texas anymore, so I'm offering this to you as just kind of an FYI, an example of how another jurisdiction looks at this particular issue, but it's not the law in Texas. Okay, so you may recall when we started this, we talked about joint several liability, so we can kind of check this one off. And now we're going to go to our second one, which is satisfaction. By the way, joint and several liability is a huge historical concept in the law. Very, very important historically, and it still continues to be important to this day. Satisfaction means payment. So when we say the plaintiff is entitled to only one satisfaction, we mean he's entitled to get 100% of his damages, but not 101%. And so he can just collect once. So let's say that, again, going back to the initial example, or my second example, Bob is 51% responsible, Ann is 20% responsible, David is 19% responsible, and Louise is 10% responsible. Ann is still judgment proof, so her 20% Louise can't collect. But because Bob is over 50% responsible, Louise can go to Bob and say, pay me your 51% and Ann's 20%. That can happen, but let's say that Ann really isn't judgment proof. Well, Louise can't collect the 20% from Ann and then I'll recollect that 20% from Bob. That would result in Louise getting recovery of 120%. Obviously, her 10% she's paying herself, but there can just be that one collection from that perspective. So that's how satisfaction works. It's a 100% deal. And of course, many times the plaintiff doesn't even get 100% satisfaction. If you go back to my first example that I gave, where Bob was only 40% responsible and Ann was judgment proof, well, unfortunately, Louise is going to be out of luck. She's not going to be able to get complete satisfaction because the tortfeasors are not jointly and severally liable. So we are done with the second topic, which is satisfaction. And now we're going to go on to contribution, which is one defendant who pays more than his pro rata share of damages is entitled to contribution from the other defendants. I already touched on this briefly when I was giving the example of, here we go, let me go back to the slides here, of Ann being judgment proof, but Bob paying her portion. Okay, so contribution is one defendant has paid more than his allocated responsibility. He or she can collect from the other defendants. Okay, and as we already talked about, and I'll show you the statute in a second, a defendant has no right of contribution against any settling person. So going back to the example where David was actually 60% responsible, but he settles with Louise, well, that might have been a smart plan for him because now he can't be held to, you know, to be jointly and severally liable. And he also can't be responsible for contribution from any, so for example, if Ann is judgment proof, Bob might seek contribution from David if David hadn't settled, and get David to pay a portion of Ann's judgment that Ann wasn't able to pay. But since David has settled, Bob is the only person who has a buddy, excuse me, who can be responsible for that payment. And here is the statute. If a defendant who is jointly and severally liable pays a percent of the damages for which the defendant is jointly and severally liable greater than his percentage of responsibility, that defendant has a right of contribution for the overpayment against each other liable defendant to the extent the other defendant has not paid the percentage of damages found by the trier of fact equal to the other defendant's percentage of responsibility. So if all David is paid, David hasn't settled in this scenario, and all that he has paid is his own percentage, but he hasn't contributed toward Ann's percentage, and in fact, Bob paid all of Ann's percentage, well, yes, David does owe Bob his pro rata portion of Ann's liability. And of course, Ann still owes it too. And here are a couple of blanks on the contribution slide. If for any reason a liable defendant does not pay or contribute the portion of the damages required by his percentage of responsibility, the amount of damages not paid or contributed by that defendant shall be paid or contributed by the remaining defendants who are jointly and severally liable for those damages. The additional amount to be paid or contributed by each of the defendants who are jointly and severally liable for the damages shall be in proportion to his or her relative percentage of responsibility. That's basically what I just said. And again, repeating, no defendant has a right of contribution against any settling person. So if David settles, he's off the hook for contribution. So we've covered joint liability, satisfaction, contribution. We're now up to release. When a plaintiff releases a defendant from any claims to be released as part of a settlement agreement, then of course the plaintiff, the defendant, can't be sued for that any longer. Okay, so we're going to talk about the problem of releases, and there's 3 ways to solve this problem. Approach A is that the non-released defendant, the one who wants to get contribution from the settling party, can seek contribution from the released defendant. So again, going back to the example, and we've already talked about this, but just to reiterate, Ann is judgment proof. Bob's had to pay Ann's portion. Bob would dearly love to go to David and say, hey, David, you know, you need to kick in some money for Ann's portion. The problem with this approach is that it discourages David from settling, because he might be thinking to himself, wow, I'm not off the hook. I'm still maybe going to be liable for this because, you know, even if I settle with Louise, because Bob may come and get me because he, you know, maybe he'll be found to be more than 50% liable, and maybe Ann is going to be judgment proof, and so I could still be on the hook, and that makes me not want to settle. Or we have approach B, which, as you can see, is the Texas rule. We've already talked about that. The non-released defendant cannot seek contribution, that this is Bob, but plaintiff's claim against non-released defendant is reduced. Okay, and after all, that is the case. Remember that whatever percentage the jury has allocated to David, the defendant who has signed a release, is not in play in terms of assigning it to Bob or Ann. So if the jury found David 20% liable, the most that it can find Bob responsible for is 80%. And the most that it can find Bob and Louise and Ann together responsible for is 80%. So David's culpability is still a factor. It still affects, positively reduces how much Bob will be required to pay. Now, the argument for this one is that it could discourage Louise from settling. But that's not really true the way we do it in Texas, because the percentage isn't what the parties agree to. It isn't what Louise and David agree to, but it's what the jury finds. And the jury might find very different numbers than what David and Louise anticipated the jury would find, or what is written up in the release. The third option is not the law in Texas. The non-release party cannot seek contribution, and plaintiff's claim is unaffected by release as long as the parties negotiate in good faith. And so in this situation, Bob can't seek contribution from David, and David's liability isn't even a factor in the jury consideration. But again, approach B, kind of the middle of the road approach, is the one that we have in Texas. And here it is. I've already shown the slides, what we've already talked about. We have each settling person, that would be David, each responsible third party, which may be someone who didn't settle but is not subject to a lawsuit. Okay, let's talk about Mary Carter and Gallagher agreements. They're the same thing, they're just different names. The names come from kind of famous cases that had those names in the case. So let's go over the facts here. This is useful to know about, although I have to tell you the Mary Carter agreements violate public policy in Texas and are therefore void. That's not true everywhere in the United States. You will see places that do permit Mary Carter agreements. So it's not a completely closed door, but therefore it's good to know, and it's a common term you'll hear people use, so it's good for you to be aware of what the term means. In the Mary Carter case, this is what happened. Two defendants guaranteed the plaintiff a certain amount of money if the plaintiff lost or recovered less than a stated sum. The plaintiff did not enter into agreement with the third defendant. Okay, so two settled, one remained. The settlement that the defendants entered in with the plaintiff wasn't your typical settlement where the defendants paid the plaintiff some sum of money and they were released from the lawsuit. But what happened here was that they agreed to pay the paint company, or I guess maybe it was Booth. I can't remember who's who in this case, but the defendants agreed to pay the plaintiff a certain amount of money if the plaintiff wasn't able to get a certain amount from the third defendant. So that part isn't that controversial, or isn't that unusual. It's kind of a high-low deal. This is the part that's controversial, though. The plaintiff refunded part of the defendant's payment in the event of a verdict against the defendant that was in excess of the contractually agreed amount. So if the plaintiff got a lot of money from this third defendant, the plaintiff was going to give a refund to the first two defendants. So what this meant was that the defendants had a motivation to make the third defendant look really guilty, and to also make the plaintiff's damages really, really sound big. And so the jury might look upon it and think, well, all the defendants are there together, but no, really, the defendants were on the plaintiff, the first two defendants were on the plaintiff side. And so this created kind of a strange appearance that the jury was not necessarily aware of. And well, they weren't aware of it because it was a secret agreement. Married card agreements are always secret. And so the jury was looking, going, wow, these defendants really think the third defendant's responsible, and they think that the damages are big. Well, why would the defendants think the damages are big unless they really were big? And so it caused the jurors to think, well, if these two defendants say it, it's bound to be true, when in fact the defendants had an economic reason to have that particular point of view. So again, they violate the public policy of Texas, and they're not therefore they're not enforceable here. This next case gives an example, kind of a high-low analysis, and similar to that married card agreement we just talked about. So let's look at this case. Again, this is not from Texas, so the decision that the Ohio court made would not be the same decision that we'd have in Texas today. So we have a patient, Michael Hodesh, and he goes in for surgery. The doctor unfortunately leaves a towel inside Mr. Hodesh's body after the surgery, and he has obviously complications from that. Eventually, Mr. Hodesh sues the doctor and the hospital, and the hospital settles with Mr. Hodesh, and the hospital agrees or guarantees Mr. Hodesh that he's going to get at least $175,000. No matter what happens at trial, Hodesh is definitely going to get this amount of money. But Hodesh agrees that no matter what the jury says, Hodesh won't try to collect more than $250,000 from the hospital. So the hospital agrees to pay this if necessary, if the jury doesn't require the doctor to pay this amount of money. But no matter what the jury says, this is the maximum that the hospital can be on the hook for. Okay, well, the doctor, probably recognizing that the hospital's maybe not completely on his side at this point, wants to get whatever agreements might exist between the hospital and the patient. The agreement is turned over to the judge, but the judge doesn't even look at it. He puts it under seal and doesn't disclose it to the jury. Well, the jury finds the doctor negligent and returns a verdict in favor of Hodesh, awarding him this amount of money. The jury found the hospital was not negligent at all. So the hospital doesn't have to pay Hodesh any amount of money. And of course, this cap doesn't ever kick in. Now you can see during trial, the hospital would have an incentive to persuade the jury that Hodesh's injuries are pretty significant, because they want it to be at least $175,000. And the hospital also wants it to appear that the doctor was the one responsible. Now you might say, well, of course, whenever you have more than one defendant, one defendant will be pointing his finger at the other defendant. And sometimes that's the case, but it's not always the case. In many cases, the defendants are of one mind, and the position they take is, we're either all liable or none of us are liable. And so the jury might be thinking, well, the hospital really thinks the doctor's liable, and the hospital thinks the damages are high. That's bound to be the case, even though the hospital really had a financial advantage or a financial motivation to make the doctor responsible and to make the damages high. Of course, the doctor sued once he found out what the terms of the agreement are, and the Ohio Supreme Court found that, yeah, these are okay. The important factor is that the trial judge found no signs of collusion during trial. If the trial judge found that the hospital seemed to be presenting evidence in a way so that it would somehow be able to escape financial responsibility. That would be collusion, and therefore the court would have been wrong not to let the jury know about that. This is really a factual issue, and very likely the judge is going to give a lot of, the appellate court's going to give a lot of leeway to the judge in making those factual determinations. Okay, so let's go back to our list here. We've talked about joint and several liability, satisfaction, and contribution. We've talked about releases, and now we're up to our last topic, which is indemnification. So what is indemnification? It's the acceptance of total financial responsibility for another tortfeasor. It's an all or nothing deal typically. You either indemnify 100% or you're not indemnifying a penny. Here are two related terms. Indemnitor is the one who indemnifies. He's the person who's taking on that financial responsibility. Indemnity is the person who receives the indemnification. He's the person being released from that responsibility. And of course, I'm using the term person, but again, I'm not necessarily talking about a human being. In fact, many cases, it's a legal entity of some type, such as a corporation. Okay, so how does indemnification differ from contribution? Well, contribution is the sharing of liability, while indemnification is the complete transfer of liability. Remember, with contribution, we were saying that Bob was sharing the liability of Anne and sharing the liability of David, but he wasn't taking over the responsibility for their portions. They remained responsible for their own portions. When we have an indemnitor, he's taking it, he's saying, I'm going to take care of that completely. The indemnity doesn't have to worry about it. So how does indemnification arise? Probably the most common way is his first choice out of a contractual obligation. It's very common in contracts for one party to indemnify another. This could be like in a products liability situation. Let's imagine that Toro lawnmowers are sold at Walmart. Well, the agreement between Toro and Walmart might well include an indemnification clause that says, well, if some plaintiff sues Walmart because of a Toro lawnmower that it purchased, and it has to do with some kind of products liability issue, well, Toro is going to have to indemnify Walmart for that. And that makes sense because, after all, Walmart wasn't the one assembling the lawnmower. And in fact, it wouldn't have been very reasonable to expect Walmart to, open up the guts of every lawnmower and make sure everything is as it should be. So that's one basis for indemnification, and it's very, very common. Another happens when a factually innocent entity pays for the real tortfeasor based upon vicarious liability. A common way this arises is in an employment situation. The employer, the entity that employs the tortfeasor, didn't want the tortfeasor to commit a tort, maybe even train the tortfeasor not to commit the tort, but the facts remains that the tortfeasor committed the tort and was acting as an agent of the employer at that time. So the employer may be responsible for indemnifying under those circumstances. When one is liable only because when he failed to discover or prevent another's misconduct, and therefore the misconducting tortfeasor must indemnify. So really, in this case, the first tortfeasor his only tort was not stopping the misconducting tortfeasor, and the misconducting tortfeasor needs to indemnify. Now, in that situation, if the misconducting tortfeasor is judgment-proof, obviously the vicariously liable one is going to, the first one, which I guess isn't vicarious liability exactly, but the first one, the plaintiff can sue and collect against in the case of the second tortfeasor being judgment-proof. When one follows the directions of another tortfeasor and reasonably but incorrectly believes that his actions are lawful, that would be another case. When a tortfeasor's victim's injuries are aggravated by negligent care, the doctor may have to indemnify the first tortfeasor for additional injury. So really, this one is the big one, and then the second one that's of note is this one. The other ones are fairly minor details in the story, and you can see that's where I had the blanks. It kind of tells you. Okay, now as far as I know in Texas, indemnification remains an all or nothing proposition, but the textbook says that sometimes courts will permit equitable indemnification, and that's where the amount of indemnities is dependent upon the relative fault of the tortfeasors. And again, so that's kind of a new twist on it. See here. Let's go on to our next slide. We have, this one is not a case you need to know about, but it is a good example about how indemnification works. In this story, we have a horse who unfortunately is injured running a racetrack and has to be euthanized. His owner, obviously, is pretty unhappy about this and sues the racing track that had the poorly prepared race surface that caused the horse to be injured, and that's the Gulfstream. And Gulfstream, though, filed a motion for contribution and contractual indemnification from the horse's trainer. And apparently there was a stall agreement, and one of the provisions of the stall agreement is a place where the horse is maintained, before and after the race, and it's basically kind of giving that horse the permission to be at this place, and giving Kimmel the right to be a trainer at this facility. Anyway, one of the provisions in the stall agreement is that Kimmel is supposed to indemnify Gulfstream. Well, there's a dispute about what the language of the contract. Kimmel's understanding is that Kimmel only has to indemnify Gulfstream when it's Kimmel's negligence. Gulfstream's position is no, Kimmel has to indemnify Gulfstream when it's Kimmel's negligence, but also when it's Gulfstream's negligence. And then Gulfstream, the racetrack also maintained that Kimmel owed the owner of the horse a duty to protect the horse from unreasonably dangerous conditions, and Kimmel, being a trainer, would have been able to see that that track was not appropriate for the horse to race on at that particular time, and so he should have stopped it. And in this particular case, that the court found both contribution and indemnification, and depending upon how the jury is going to rule, certainly Kimmel may need to indemnify Gulfstream. So again, that's just an example that may help clarify kind of what we're talking about when we're talking about indemnification. So if you have any questions, please bring them to class. I'll be glad to answer them. Thanks for your attention, and have a wonderful day.